Welcome to Counsel, a video series where we chat about the issues keeping employers up at night. I'm Andy Sherrod, and I'm here today with my colleagues Jamie Weisgarber and Matt Sarfan. We're all members of Hirschler's employment law team, and we're here again on the topic of the FTC's rule on non-competes. As we discussed in a previous episode, the rule would have done three things. It would have prohibited employers from entering into non-competes with any employees after the effective date, which was supposed to be September 4th of 2024. It would have made existing non-competes with certain limited exceptions unenforceable as of that date, and it would have required employers to give notice to workers whose non-competes would have become unenforceable under the rule. But the rule was subject to legal challenge almost immediately, and now the courts have definitively stepped in. Matt, tell us about the ruling.
Of course. So we were initially tracking three separate lawsuits. The first is the Ryan LLC lawsuit out of Texas. The next is the ATS Tree Services lawsuit out of Pennsylvania. And the last is the Properties at the Villages lawsuit out of Florida. Until August 20th, the courts had made preliminary rulings regarding injunctions in these cases, but hadn't issued any definitive decisions regarding the final merits of the case. But on August 20th, the court in Texas in the Ryan LLC case issued a ruling in favor of Ryan LLC, ultimately holding that the FTC had exceeded its statutory authority and that the rule itself was arbitrary and capricious. So, based on that reasoning, the court held that the rule was unlawful and set it aside. So what we do know is that the rule is not going to be going into effect on September 4th. But there's still a lot of uncertainty out here for employers and our clients. So, Jamie, could you walk us through a little bit of that?
Sure, Matt, there very well could be an appeal. The FTC has indicated that it is considering an appeal. But pending changes as a result of an appeal, we are now back to the pre-rule era of the status quo before this rule went into effect. And what that means for employers is that they should be reviewing their non-compete agreements to make sure that those agreements are necessary for the employees that are subject to them, and also that those agreements are compliant with applicable state law. Remember, certain jurisdictions have laws that ban non-competes or that restrict them for low-wage workers, for example. So you want to take all of those things into consideration when you're reviewing your agreements. The big takeaway here is that non-competes, there is not a one-size-fits-all approach. You really need to tailor them based upon the jurisdiction and the employee. If you have questions about your non-compete agreements, or if you need somebody to take a review to review it, please feel free to reach out to the Hirschler employment team. Thanks so much for listening.